Good evening, everybody. Thank you so much for joining us this evening. I'm Constantina Papageorgiou. I'm one of the partners at Vishnick McGovern Malizio. I, along with my colleague, Kristine Elliott, Garcia, work together, estates and the elder law departments. Estate planning we do day in, day out, evenings, midnight snacks, everything in between. So we're delighted to have you here. We just want to introduce what it is that we do at the office and explain to you why estate planning is so important, especially for young families. I feel like a lot of people think, right, Kristine, that like you have to be a certain age, you gotta have a certain amount of money, you have to be of a certain monetary caliber to do this planning. And it's actually not like that at all. The amount of money you have doesn't dictate whether or not you should have estate planning done. So it's really, really important that you engage in planning. So I think, Kristine, you'll start us off, right?
All right. So I think if there's anything we've learned in recent years is that life-changing events happen without notice. So it's important that we plan so that when life happens, we have our things in order and we're not caught off guard, right? So some of the sort of basic documents that we're going to talk about, which is the core documents of our estate plan, are a power of attorney, healthcare proxy, living will, your last will and testament, and the designation of a guardian, right? And that's super important for the individuals that have small children who, something happens and now another family member, friend has to take charge. All right, so we'll start with the power of attorney. The power of attorney is probably the most important document you will sign that will be effective during your lifetime, right? During your life. You'll appoint an agent to act on your behalf. Essentially, this individual steps into your shoes and is able to make financial decisions on your behalf. That's everything from banking transactions, calling insurance companies, selling or buying real estate, accessing your devices, literally everything that you'd be able to do, this person can do, right? In the event of incapacity, the power of attorney can also step in. Your agent can step in to transfer assets, should we need to do that in order to get benefits or anything in place to protect your assets while getting you the help that you need. And ideally without depleting your life savings. The power of attorney also allows us, again, in event of incapacity, to avoid the Article 81 guardianship proceedings, which can be very lengthy, very costly. And ultimately, if these documents are in place, we can avoid them, right? And avoid the constant court intervention in our lives.
And so Kristine and I can talk bad about guardianships because all we do is a big part of our practice is guardianships. So what does that mean, right? So let's say somebody had a stroke yesterday. I never say tomorrow. I always say yesterday. If somebody had a stroke yesterday and they do not have a power of attorney in place, then you may not have any ability to get into their assets, to access their records, to be able to transact business on their behalf. I'll give you an example. My 401k, it's in my name alone. My life insurance is in my name alone, right? So if I had a medical situation where I was not able to talk to Merrill Lynch on the other line and say, yes, you can speak to my husband about my 401k, my husband does not legally have the right, despite being listed a beneficiary on my 401k, he does not have the current right while I am alive to get any information about that asset. He can get into our joint accounts. He can deal with anything that has his name on it along with mine, but as long as he is a joint owner, not if he's a beneficiary. So when someone is a beneficiary, they only have access after you've passed away. But while I'm alive, he has no access to any of that. So that power of attorney gives him the ability to step into my shoes to transact all business for me, to apply for disability if I'm not able to do it, to apply for unemployment if I have to stop working, right? To be able to access my medical records, my financial records, my historic records, anything. All of that is protected under the law. And even though I'm married, my spouse does not have that automatic right to get my personal and confidential information. Even right after I had had my daughter, right? And I called the insurance, we were under his insurance. And I tried to get information. What's our out-of-pocket maximum, our deductible? Did we meet it? This and that. And they said they couldn't talk to me, even though I was one of the insured parties on the insurance. They said, well, it was his policy. I was not allowed to get that information. So that power of attorney is really a key. And by having it, you're allowing the other person that you trust, and if not your spouse, if it's a close relative, if it's a good friend, if it's somebody else that you trust, to be able to step into your shoes, to pay your bills if you can't, to deal with everything that you may not be able to do one day while you're still alive, right?
And on that note, it's really important to make sure you pick someone that you really trust, right? Again, your spouse, it's, could be a joint owner, it could be a beneficiary, but what happens if your spouse is unable, right? Or, now we're next in line. Who's the next person in line? Or who do you want to transact along with your spouse? Should you, for example, both be part of the same, catastrophic accident or whatever, right? Ultimately, you want to make sure that you have a plan in place and a backup plan. So we always discuss different scenarios with clients about how to best plan for those worst case scenarios, right? Like I said, this is one of the most important documents you will sign, and it is valid the moment you sign it. We tend to not recommend springing powers because ultimately it becomes harder to get a medical provider to sign an incapacity, determination, et cetera, to get those powers to kick in, when ultimately this is really something that we want to be ready to go when we need it. Again, it's valid until you revoke it or until you pass away. At the time of your passing, it can no longer be used to access anything. So that's really the key points as it relates to the power of attorney. All right.
And if I could just jump in, if anybody has any questions, feel free to add it into the chat. We'll try to answer them as we go along. Or if you have questions at the end, that's fine too. Just make sure you type it into the chat.
Thanks. So the next important document is, think of a power of attorney for your health, right? It's your healthcare proxy. And you would be appointing an agent to make medical decisions for you, should you be unable to do them yourself. Now, the doctor is always going to defer to you as long as you're able to communicate your wishes, and that stands. But if you're in a coma or you were taken into emergency surgery and you're sedated and you can't make those medical decisions, the doctor is going to defer to your medical provider, to your agent, to make those decisions for you. Just 1 second.
Sorry, I saw that the chat is disabled and I'm going to fix it.
All right.
Go ahead.
So as long as, again, you're able to make those decisions, you make the decisions. If not, your agent steps in. In this case, unlike the power of attorney, where you can name multiple parties across the board, the healthcare proxy allows you to appoint one agent at a time. The idea is that the medical providers do not want to get into it or have issues, when family members don't agree and you're all standing in the, waiting area of the emergency room, right? So the idea is that there's one person who makes those decisions. That person's not available, next in line steps in. Again, your healthcare proxy is only valid while you're alive. When you pass away, the document is no longer valid. It can also be revoked. A new one can be done, and new individuals can be appointed as your healthcare agents. Right along with that is your living will, not to be confused with a last will and testament, okay? Your living will is a document that really tells your agents what medical care and treatment you want and don't want at the end of your life. Should you be in a condition with no reasonable expectation of recovery, do you want to be intubated? Do you want, resuscitation, artificial nutrition, hydration, etc.? If you don't want that, then it should be communicated and it really should be spelled out, right? So this document allows us to say those things exactly how we want it, so that when your healthcare agent has to face those difficult decisions, they're able to make them and make them comfortably, so they can honor your wishes without necessarily feeling guilty that, you're suffering, etc. No, this is what you wanted. You laid out your wishes and they're honoring your wishes.
So I think it's really important here to differentiate a living will from what you may have heard. You may have heard of the term DNR or DNI, right? A DNR is a do not resuscitate. Typically, a do not resuscitate is signed when somebody is at the end of their life. So a doctor needs to countersign a do not resuscitate order. It's not something that I can give you that you can sign, right? Nor do I want you to sign it, because if you collapsed, we want to be resuscitated so long as you're in decent health, right? You have life to live. But a lot of times these documents, the living will specifically, comes into play and we only really use it. I tell my clients, like, don't give that out. Unless someone is at the end of their lives, there's no reason to hand out the living will. The living will is very clear. It says, in the event that I'm suffering from a condition that is incurable or irreversible with no reasonable expectation of recovery. What does that mean? End stages of some sort of horrible illness, pick cancer, you're in terminal stages, you're at the end of your life, you've exhausted all potential treatments. In that kind of a scenario, the doctors typically give you the option. Do you want to sign a DNR, do not resuscitate order, right? Or a DNI, which is a do not intubate, meaning don't give me artificial respiration, right? And so the living will authorizes your healthcare agent, the person you've designated under document 2, to be able to sign the DNR or the DNI at that point. Now, if you're capable at that point of making that decision, you're the one who signs the DNR and the DNI. But if you're not, that's where your healthcare proxy steps in to do it for you. So just because you sign a living will doesn't mean that you're saying, don't resuscitate me. That's not at all the case. It's just giving instructions to your loved ones to say what you want to do. Like, I know I've signed a living will and I told my husband, you better fix me, right? I don't want to die. But if I'm in that state where I've suffered some sort of traumatic brain injury and there's no recovery, then I don't want to live on machines and artificial means, right? But fix me. That was my instructions to him. And I warned that if he doesn't fix me, coming back to take him with me. So that was my threat.
Your husband's not alone. Mine is right there.
Right.
So this sort of leads into the next very important document, which really only applies to individuals that have minor children, right? Should you be in that mentally incapacitated state, physically debilitated, disappeared, detained, missing,
or had a wild night out, you were arrested and you're being held against your will in jail.
Right.
I like to think fun.
Then we want to have a designation of standby guardian that's going to appoint someone to step in to take care of our children should we not be able to do so, right? And this also applies should we pass away, right? Upon death, this document, right, it's in place. We absolutely need to name guardians in our last will and testament for our children, and they should match, right? But ultimately, the idea is that in those first days when everything may be just, not good, you're mourning, you're dealing with so many different things, there's something in place that allows you to really feel comfortable knowing that your children are going to be taken care of, that there is someone in place who will be able to then step in, take care of your children. Ultimately, the guardian, the named guardian, will have to go to court and be formally appointed as the child's guardian. But this buys you some time. This also tells the court exactly who you wanted to take that position, right? Or sometimes there's arguments, right, between family members, siblings, grandparents, whose side of the family takes the child. So it's important to name someone to step in when you can.
And so that guardian, it's really important to note that the guardian is really only a person who physically cares for your child until 18. The guardian is no longer a guardian, just like we are no longer our kids' guardians once they're 18. Once they're adults, they're on their own, whether we like it or not, right? The law sees them as independent people. And so they have their own privacy. They need their own power of attorney at that point. They need their own healthcare proxy at that point to enable you to be able to still access records and do things for them. But a guardianship ends at 18 years old. And so whether you like it or not, they're on their own, right? So it's really important that you pick the person that you trust that's going to be able to care for your children and to be able to step in to physically make decisions on where that child's going to live, where they're going to go to school, right? What kind of activities they're going to be involved in. That's who the guardian is going to be. They are going to physically care for your children until they reach the age of 18. Now, there are some questions in here, and I will come back to the power of attorney question. There's a question about in a divorce situation, can you add someone after your spouse? Absolutely. I think you should go down the list, right? You should come up with your primary if there are two parents who are going to be responsible for the child. It should be the parents first, right? Then it could be whoever you want. And I would recommend you go down the list, right? If let's say you put your parents or somebody older second, I'd say you go down at least one more level to make sure that if the people who are older than you are not able to do it at the time that it's needed in 10 years from now, in 12 years from now, 15 years from now, at least you have a backup. And can you have more than one person as a guardian for your minor? That gets a little bit tricky because a lot of times the guardianship will require, questions as to where the person lives, where they go to school, right? They have to sign documents, and it's hard to do when they're not in one household. If they're in the same household, like spouses, absolutely, I think it's much simpler. But if you want to, give guardianship to both of your siblings, let's say, who don't live in the same house or who are not in the same household, I think that gets a little bit more complicated. But yes, you can designate more than one person as the guardian. You can also designate one person for guardian of the person, of the physical child, to make their medical decisions and where they're going to live. And you can designate a different person as guardian of their property if there was a need for that guardian of the property.
So while we never want to face the idea of passing away and leaving our children behind and sort of thinking about who's going to take care of them and who's going to manage funds, etc., it's best to be prepared. And part of being prepared is also having a last will and testament in place. A properly drafted last will and testament is going to accomplish a couple of different things, right? It's going to outline how you wish to distribute your assets. It's going to designate an executor to administer your estate, right? Everything from paying your debts to distributing the remaining assets to your beneficiaries. Again, appointing these guardians who are going to step in the time of need, and potentially establishing testamentary trusts and other protective measures that can help, again, with individuals, right, children with special needs, or again, minors. We're talking about even safeguarding assets from creditors, right? Like
spouses.
And again, in case of divorce, right? So these are the kind of things that are important to have very candid and open discussions to make sure that whatever will is being drafted really takes into account all these different situations so that you're fully covered. Having a will doesn't mean that, you just get to, the executor is there and all of a sudden you can access bank accounts and do whatever you want. No, we still need to go to court. The will needs to be probated, but at least you have laid out your wishes so that the judge knows what you want. If you don't, you die intestate, and essentially the law dictates what your estate plan is. And that doesn't always line up with what we want, right? So for example, you were in the process of a divorce and you pass away. The law says that your spouse is going to get half and then some.
50,000 off the top plus 1/2 of the rest.
And now what you thought was going to just your children is going to be going to your spouse that you were already planning on divorcing. So those are some of the things that, again, if that's your situation, it's best to update your plan so that you avoid those type of situations.
Even
Again,
if it's not your situation, sorry, right? Even if you're married, and
happily
you have
married.
children, happily married, you have kids, but you intend to leave everything to your spouse, right? If I died without a will, and let's say I had $100,000 in a bank account, right? That $100,000 would go 50,000 off the top to my husband, plus half of the rest. So he would end up with $75,000, and the remaining half would go to my 2 girls who are 7 and 9 years old, right? Now, the remaining half is going to be $25,000, which is split 2 ways. Each daughter will get $12,500. But here's the problem. Without a will, and because my daughters now inherited assets and they are underage, what's going to happen is that my husband will have to go to court to become the legal guardian of my daughter's property. Remember before I said you could be guardian of the person and guardian of the property? My husband is automatically guardian of the person of my child, as am I, right? As the parent, the natural parent, we are guardians already of their person. But my husband is not technically the guardian of their property. He may be spending tons of money on them, but he is not the guardian of their property until the court appoints him. So in order for him to collect that $12,500 for each one of my girls, he's going to have to go to court to tell the judge, hey, Constantina passed away. Stella is entitled to $12,500. Olivia is entitled to $12,500. And I will become the guardian of each one of those girls' money so that I can collect their $12,500 each. At that point, he submits paperwork to the court. He gets authority to collect the money. He puts it into a joint account with the Surrogates Court of Queens County, which is where I live. And anytime he wants to withdraw from that $12,500, he has to submit documentation to the court to prove why he is going into the girl's money to be used, right? Now you're going to say, all right, for $12,500, I'm going to tell you it's not worth it for $12,500. He's going to have to file annual accountings every single year to tell the court what the value of the account is at the time of the annual accounting, which is a year from your anniversary. And he is going to have to get permission anytime he wants to spend the money, because again, the account is jointly held with the Surrogates Court of the county where I died and I lived. So it's not a fun proceeding at all. There's a question here is, what might happen for same-sex couples for estate planning if it's no longer recognized in the United States? That is a very, very difficult question to answer. Already for our own estate planning, in our wills, we do write that I leave, for our same-sex couples, I leave what I have, or I leave everything to my spouse, even if they are not deemed my spouse for purposes under the law, because we have a really great LGBTQ plus department here, and we're very conscious of this stuff, right? So we pay a lot of attention, but we do include that wording that says, even if we are not deemed to be spouses in the state wherever we die, I still leave everything to my spouse, this person, and we name the person, regardless of whether or not we are deemed to be validly married, right? I think that given the current climate and the concerns about that changing in the future, there is even more of an urgent need to put it in writing and to say that you leave it to your partner, to your spouse, to this person individually, no matter what, regardless of whether or not you're deemed to have a valid marriage at the time that you pass away. But yeah, so this is how it would work if you did not have a will. which obviously you see can be a really difficult scenario, not only for the spouse, but also for the kids. And an important part that I didn't mention yet is those kids, right? So if my daughter's inherited that $12,500 in that guardianship account, they're actually going to get it all when they turn 18. My husband has no choice. The money goes to them directly, which is not a big deal if it's 12.5 grand. But what if it's $1 million life insurance policy that now the kids are receiving, right? At that point, do you want a bunch of 18-year-olds walking around with $500,000 apiece? I don't think I do.
I think so.
Right? So it's really important that that will gets done and that in your will, you include certain provisions. And I think, Kristine, you're going to.
Yeah, I mean, great segue, because ultimately the will still deals with probate assets, right? So what happens to those non-probate assets like life insurance? So it's important to check those beneficiary designations. It's important to check with your retirement plans, make sure that they are up to date and what you want is being distributed to exactly who you want. But keeping in mind that you shouldn't name minors as the beneficiaries of life insurance policies.
Or bank accounts or brokerage accounts. Minors should not be beneficiaries on any non-retirement accounts. I cannot urge that enough. And it's because of that guardianship that we were just talking about. A minor cannot collect funds. They cannot be the owner of money. There needs to be a guardian appointed to collect those funds for them. And then it creates this whole other nightmare that I was just describing to you. Oh, sorry.
So now,
I'm very passionate about the guardianship stuff.
So that sort of sets forth your core plan of estate planning documents, right? But that it doesn't really end there, right? If we want to avoid probate, if we want to sort of set more layers in place, if we own property, if we may own multiple properties, etc., we may consider trusts, right? So Constantina is going to jump in and talk to you about trusts and other concerns that we have and how to deal with them.
So I just wanted to also add for the will at this point, right, that when you create a will, your will says, right, we talked about what happens when you don't have a will, but when you have a will, what you want to include in your will is who you give your assets to and when you want them to get those assets. So I'll give you an example. If I passed away yesterday, again, I say, my will says I give everything I have to my spouse, right? If something happens to both of us, we give everything we have to our girls. But we don't want our girls to have access to that money at 18, even at 25, right? So within our wills, we create something called a testamentary trust, which basically says that if our girls receive any assets when we die, if we're both deceased, until they reach the age of, don't laugh, 35 years old.
Maybe 50, it could be 50.
And we're going to see how it goes. But right now, the way it's looking, it's going to be 35 for the time being, right? So until our girls get to the age of 35 years old, I don't want them being able to have access to their funds. They're too little. I don't know if they're going to be responsible. I don't know if they're going to blow through it. They're going to want to spend it on expensive cars or probably vacations or whatever the situation is, right? Right. Nothing expensive, right? So in my will, I don't want them to physically access their funds until they get to the age that we've designated. So we said until they get to 35, I have my sister managing their funds in a trust, right? Now, this trust is the testamentary trust, which is going to be different than the living trust that I'll address in a minute. Testamentary trust will get created if we both die. My husband and I are both deceased and the girls are under 35 years old. Those are the two conditions that are met. If they're under 35, my sister will collect their funds, one trust for Stella, one trust for Olivia, right? Before 35 years old, my sister will be the trustee who will manage those funds. She'll invest it. If there's real estate and she decides she wants to rent it, she can do that. She can sell the assets that are in there. She can convert everything to stocks and bonds. She runs it like a regular account. And whenever my daughters need money for their health, education, maintenance, or support, my sister will use those funds at her discretion for their benefit. So if Stella wants to go to Harvard, her aunt can use her funds to pay for Harvard. It's education, right? But if Olivia wants a Maserati, her aunt could say, well, how's a Honda, right? Or a Mazda or something else. That's not a $400,000 car. And that's the idea. The idea is to protect your kid from themselves. And that's why I chose 35. I see too much. As a trust and estates attorney, I'm very, very pessimistic about the world and how money works. So I tend to see people who inherit money and just blow through it. So I worked way too hard to let them blow through it. So I will control a little bit after I die. But I've made arrangements that at age 30, they'll get half of their assets. So if, let's say, there's $500,000 left in the account, Stella will get a check for $250,000 when she turns 30. And then if there's another $250 left when she turns 35, she'll get the balance, right? And that was kind of how we set it up. There's no magic number. Everyone's like, well, what do you think I should do age-wise, right? For me, it was really important to consider my kids, right? But they're too young, so it's hard to know their personality and how they're going to manage their funds. But it was also important to consider the amount of money that I'm planning on leaving them, right? I am worth a decent amount of money dead. I have tons of life insurance, right? Alive, not so much, but dead, yeah, definitely, right? So I don't want little kids, 18 or 21-year-old kids or 25-year-old kids walking around with a couple $1,000,000. To me, it doesn't seem right. But each person has their own personality and their own thoughts and their own feelings, and they get to choose what they want, right? And the ages that they feel the most comfortable with. Like Kristine's kids are older. She has a better sense of how they are with finances, whereas mine are little. I have no sense of how they are with finances.
And I think it's important to take into account what your individual family circumstances are, right? Sometimes we meet with clients who have no family. It's an only child. You know, there are no friends that they may really trust to manage funds. You have a very responsible child who has shown that they can manage funds very early on. And then, you know, it may make perfect sense to just leave it for them to manage. And look, maybe even, again, we're talking testament to, but leave it in trust for the rest of their life so that when they get married, you know, should they get divorced or other things happen in their life, it is still protected for the rest of their lives. So those are some of the things that we think about. And it's important to, again, really be honest about and think about your children, right? And your plan and your family, right? The dynamics to
Be realistic.
Be realistic, right? So that you can really plan with those things in mind. And look, you should always review your estate plan every couple of years. Make sure, you know, that the people you've appointed are still around, still available. You still have those good relationships because things change. But certainly the goal is to create a strong estate plan so that you're not, you know, changing things up every year or so. It really depends, right?
So there are two questions here I just wanted to address. There's one that says, can you put different ages for different types of assets they'll receive? For instance, bank accounts at one age, life insurance at a different age. The composition of your assets is going to change through time, right? So if you pass away and your child is a minor, you don't know how much is going to be in each respective account. What I would say is if you want them to receive a certain amount of money at a certain age, you could say $25,000 at age 21. You could say 100,000 at age 25. I wouldn't pick the specific assets just because you don't know what those assets will be at the day that you die. But like I said, you could do them in increments if you want. So you can tailor that however you feel is appropriate. And there's another question that says, if both parents pass, does the guardian have to prove that the funds are being used on things like education, health, etc.? So the trustee is actually the person who's managing their funds within this trust that's created in the will, right? And the trustee technically is accountable to the beneficiary, whether it be that beneficiary's guardian or if the beneficiary is over 18 years old, to the beneficiary themselves. And they're supposed to render annual accountings, which show this is how much I've collected, this is how much I've paid out, this is how much I have left at the end of the year. And so if that trust continues for years, they give an accounting annually. And that's how that would be done. Now, I wanted to move. So Kristine talked about the 5 basic documents, right? We said power of attorney for finances while you're alive, healthcare proxy to make your medical decisions while you're alive, living will to assist with your end of life decisions, again, while you're alive, designation of standby guardian who's going to handle and take care of your kids if you are sick, right? And you're not able to, but you're still alive, or if you're deceased, and your last will and testament. That's the base. That's where you should have a minimum of your estate plan should be those 5 documents, right? And then we build on it. Sometimes people stop right there and they say, you know what, I don't need anything else. And that's fine. Sometimes we do more complex planning. It all depends on the circumstances. So we talked about a testamentary trust. Now, a will always has to go through a court process. It's called probate. Kristine alluded to it before, right? The probate process is the process at which a will is deemed to be a valid document. So just because I died, even though this says this is Constantina's will, doesn't mean that it's actually Constantina's will. This will be Constantina's will once the judge says, yes, this is a valid will that Constantina drafted, right? And that process is the probate process, which in a typical situation with adult children and non-disabled individuals and love in the family and nobody hating each other and things going equally, I'm not afraid of probate. I'm a trust and estates attorney. I probate things all day and all night. So I'm not too concerned about it, right?
Not always typical what we see.
Correct. So in certain circumstances, it's really, really important that people consider drafting living trusts, what people call as living trusts. Now, there are 2 kinds generally of trusts, living trusts, right? Ignore the testamentary trust we talked about in the will. A living trust comes in 2 forms. We said revocable and irrevocable, right? Now, in either one of those circumstances, I always describe it, don't laugh, but I always do this. And every day, this is how I describe trust as a box, right? So you put your assets into this box and you close the box. Now you have 2 options of what to do with the key when you lock up the box, right? Now, remember, this is not technically a box, it's papers, right? That's what a trust is, but imagine the box. And so you transfer your assets into this trust. If you lock up the box and you keep the key, that makes it a revocable trust. That means you can revoke it, you can amend it, you can undo it at any point in time. You're in charge, you have the key, you can go in and out, you can put your assets in, take your assets out, it's yours. The other option is an irrevocable trust. An irrevocable trust is when you put your assets into this trust, you lock it up and you give away the key. You give away your control. You give away your rights and your access, maybe not all your rights, but some rights to the assets that you've locked up. But it's for a purpose. Typically, it's to avoid creditors or to move assets out of your estate for tax purposes, right? There are a lot of different reasons that we would create irrevocable trusts. The biggest one that Kristine and I use is for long-term care planning, which is going to be another part of the presentation, right? Protecting houses, making sure assets are shielded from Medicaid, creditors, liens, things like that. Now, for our purposes, I'm going to talk more about the revocable trust. So let's say you transferred your assets into a revocable trust. That means you can title your property into the revocable trust, your house, your shares of your co-op, right? Your apartment. You can transfer your bank accounts. That just means that going forward, instead of it being in Constantina's name, it's in Constantina's revocable trust's name. But the beauty of the trust is that when I die, that key passes on to the successor trustee, to the person that I've named to take over after me, without having to go through court or probate, right? So that's why we really like these revocable trusts, because we tend to use them when we want to transfer assets without court intervention, without additional fees, right? Without the extra time that goes into having to probate, the time, the expense, and the frustration that comes with having to probate, especially when we have young kids, because probating a will when you have young children is more cumbersome and more difficult and can be more expensive. So revocable trusts are really good tools that we use to ensure that when we pass away, it kind of says in it, it does say in it, it takes the place of a will, and that it says, while Constantina's alive, all this money in the trust is hers. But when she passes away, she gives all her money to her husband, right? And her successor trustee is her husband. So if I passed away, my husband now takes over the trust, gives everything to himself, puts it in his own trust or however it is he's going to do it. And then when he dies, he can say it passes all to my girls and it'll go into a trust for the girls. So essentially, that will continue without, like I said, court intervention, probate, and additional costs and time. Now, there are several questions here, so I want to just pause for a second to go through them, right? With regard, there's a question here about the pros and cons of having a professional as a trustee versus an individual that you know. So this is a really personal question in the sense that individuals can be trustees. It doesn't have to be a professional. It could be somebody that you trust and that you know is good at finances, right? You may have a sister who's very good at parenting and you want her to be your guardian. And you may have a sister who's very good at finances and you want her to be the trustee, right? It doesn't need to be a professional. It doesn't need to be an accountant, an attorney, a financial person. It should, though, be somebody that you trust to make the right financial decisions. So if there isn't somebody in your life who can do that, a professional makes sense. Putting a professional in place to manage your trust would be a better bet if you can't trust somebody in your life to do it. Now, the negatives of putting a professional in is that they're entitled to fees, right? Whether it be commissions, everybody's entitled to. But let's say you nominated an attorney would be entitled to legal fees and commissions, right? Or a financial broker. I don't even know that they'd be able to serve, by the way. Some of their brokerage companies don't allow them to do it, but they could be entitled to commissions and they could be entitled to their fees also, right? So it really depends on the circumstances, but it's, I think, a person by person analysis as to whether or not it makes sense to have a professional. Another question, are there tax disadvantages to leaving a testamentary trust as a beneficiary or on a life insurance policy? We're going to talk about taxes in a minute, so I'll want to get back to that question. Can you have more than one trust? Absolutely. We have trusts for different reasons, right? So if I have a decent amount of money in my estate and I want to start passing assets to my kids and removing it from my estate, I may have an irrevocable trust. But if I want to keep assets in my name, I may have a revocable trust. I have many clients who have multiple trusts. They all do different things. So you just have to decide what it is that you're trying to achieve so that we could be able to make a decision as to what type of trust works best for you. And there's another question, at what age do you recommend getting a revocable trust? There's no specific age. Everybody's circumstances are different. There are people who should have revocable trusts and there are people who really don't need revocable trusts. I'm not that attorney. We are not those attorneys who walk around saying everybody needs a trust. I don't necessarily agree with that. So I think, again, it's a case-by-case decision. Can there be trust within other trusts? Absolutely. So one huge benefit of trusts is that I can have those trusts continue for the next generation, right? So let's say I created a revocable trust for myself that would benefit me during my lifetime. I'm in control of it. But when I die, I want my trust to break into 2 trusts for my girls. A big benefit is, again, it doesn't go through the court process. So I can create a trust for Stella and I can create a trust for Olivia that can continue for the rest of their lives to protect them from creditors. I call it creditor protection trust. So Stella's portion, let's say she gets $1 million, would not end at age 35, like what I said in my will, but would continue for the rest of her life. And at age 35, she can now become the trustee of her own trust to manage it forever, right? Until she passes away. And when she passes away, I would state that it passes directly to her kids. So that is one really good way that we're able to pass down wealth, right? From generation to generation. Now, if we want to do things like dynasty trusts, those get a lot more complicated and, not always honored in New York State. So they have to be structured a certain way in accordance with the law, right? But there are ways that we can pass down, make several trusts in our trust. Can you give assets to your children when they turn over 18? Absolutely, you can. You can give assets to your kids whenever you want once they're adults, right? So if you decide 18 is the age, that's up to you. Absolutely, you can. And you can have, look, there are times where we want trusts to continue for the lifetime of somebody for many reasons, right? If we have a disabled beneficiary, a child who has a disability, we don't want that child to ever lose their government benefits, right? Kristine and I do this stuff all the time in the sense of special needs planning. If we have a child who has a disability, who's receiving Medicaid, OPWDD, food stamps, any other kind of rental assistance or any other kind of benefits, we want to make sure that whatever inheritance that child receives does not kick them off of their benefits. And so it's very important that a special type of trust is set up. It's called a supplemental needs trust that will hold their inheritance for the rest of their lives so that they do not lose their benefits. And then you would want a third party, whether it be a sibling, a cousin, whoever you trust, to manage those funds for the rest of that child's life. They are not allowed to manage their own funds in a supplemental needs trust. So that's a really important point. I'm going to address a couple more questions and then I'm going to jump to the next topic just because I know we're running low on time. I could talk about this all day and all night. Can an irrevocable trust stipulate additional beneficiaries in the event that all issue of the grantor, issue is children, I like that you're using the legal term, of the grantor deceased? So I absolutely always put a disaster clause in my documents, whether it be in the will or in the trust, right? That basically says if something happens to myself, my children, and I have no grandchildren, I want my assets to be distributed as follows. So absolutely, that should definitely go in all your documents, especially if you have a smaller family, right? Can you update beneficiaries at any times? Absolutely. Revocable trust can be changed at any time during your lifetime, as long as you have mental capacity, right? The minute you become incapacitated or you're not able to make decisions, you're not making sense, you're not capable of handling your finances, that revocable trust becomes irrevocable and you can no longer change it for your own protection, right? You don't want someone who doesn't know what they're doing changing their documents. And then the last question I'm going to take right now, how does a supplemental needs trust work within an irrevocable trust? So typically, you can either create a supplemental needs trust itself and make it irrevocable, right? There are two kinds of supplemental needs trusts, which is a whole other topic in itself. But you can create a supplemental needs trust to operate right now, or you can create a supplemental needs trust to kick in at your death, right? Whether you do it through your will or through your revocable trust. So I can go deeper into that probably in a little while. I just want to make sure we get through most of the presentation before I dig too deep into the S&T planning. So essentially, that's how trusts work. And I think that that's a really important discussion that needs to be had and addressed as to whether or not a trust is the best way to plan for you. And so there are two other concerns that I have that I always bring up to my clients whenever we're talking about planning. The second concern is long-term care planning. Because we are elder law attorneys, right? This is a really big concern of ours. And it may not be a concern of yours and you're not thinking about it yet, but I really want you to. I'm sorry. I want to give you more stuff to stress about and worry about.
It's important to plan.
You
and if
have
you
to
do it
plan.
early, it can be more cost efficient as well.
Yeah. So long-term care planning, right? As people may know, dealing with their parents, their grandparents, their aunts and uncles, right? If you get to a point where you need care, long-term care, I'm not talking about you need a nurse to come because you've been released from the hospital or you need rehab services temporarily. I'm talking about if you need help on a day-to-day basis, permanently or almost permanently, right? In that kind of a scenario, health insurance does not cover you. I want that to be very clear. Medicare does not cover it. Supplemental insurance does not cover it. Oxford, Aetna, these do not cover long-term care. They cover short-term care and short-term rehab services, but not long-term care. So if I get to a point where I'm, let's say, suffering from dementia, or I've had a stroke, or something else has happened to me medically, and I'm not capable of taking care of myself and I need an aide to come and help me at home, or I need to go into a long-term care facility, i.e. a nursing home, right? In that scenario, there are 3 ways to pay for it. The first is through long-term care insurance, which a lot of people do not have. But I think for our generation, this is going to be really, really important to do. It's important to talk to your financial advisors. I always tell people, estate planning is not just about filling in forms. Estate planning is a whole pie, like a round pie, right? Part of it is the documents. Part of it is the long-term care planning, right? Part of it is the life insurance planning. All of that ties in together, and financial planning is estate planning. So it's really important to speak to your financial advisor, whether they tell you to put, you know, some money away every year into a certain account that's going to grow at a certain rate, and that'll be your long-term care fund, or whether they recommend that you buy a life insurance with a long-term care rider, right? Whatever the situation is, and I'm not here to give you financial advice, but I'm just here to put it on your radar that it is really important to consider that as part of your plan, right? So the first way is to pay through long-term care insurance. The second way to pay is to pay out of pocket. Just pay for the care that you need. Now, if I tell you what it costs, I don't think you're going to like it, right? What are we paying right now for a home health aide? What is the minimum that you're seeing hourly rate?
Looking at anywhere between $28 to $40 an hour to have an aide come to the house. If you're looking at a facility, it can be anywhere between, you know, $575 and $700 plus a day, right?
Parker Jewish is $875, and it's not nicer. So yeah, I would say it starts at about $500 an hour, it goes $500 a day, right? So in a month at the cheapest nursing home in New York State, you're probably looking at a $15,000 nursing home bill, and your insurance does not cover it, guys. So it is really important. As you see, we're very passionate about this because we help people, right? If you call me and you say, my grandma had a stroke yesterday, we don't know what to do. That's where we spring into action to help try to protect whatever we can, right? And that takes us to the third. Go ahead.
No, and on that same note, you know, we always think about the older adults that we help, but we've recently come across several young clients who have had serious health issues, accidents, right, that have left people, you know, physically and incapable, right? So it's important to plan with an eye towards, you know, we don't want to think about worst case scenario, but, you know, what if we walk outside and slip and fall, right? And now all of a sudden we're in wheelchairs and we need someone to change us every day. Those are the kind of scenarios that we see all the time, and it's very expensive. It takes months to get some of these services in place, and your life savings is gone. You know, so often people are like, oh, I work, I don't need Medicaid. Believe it or not, when this happens, you're going to want Medicaid. Otherwise, every penny is gone. And then what's left behind to care for your children,
family, right? And that takes us to the third option, right? So the first option we said was long-term care insurance. The second option was paying privately, paying out of pocket at the numbers we just gave you. And that's today's numbers, right? We're not even 40 yet. By the time we get to 80 or 90, what is that cost going to be in 40 or 50 years? I have no idea. I can't, like, I don't even want to think about it, right? That's your second option. Your third option is to engage in planning to protect your assets so that you can qualify for Medicaid. Now, I am not telling any of you right now who are in your 30s, 40s, 50s to start, you know, moving your assets so that one day in the future, if you needed Medicaid, you can qualify. Right now, Medicaid is an option today, February 6th, 5th. I think I've written the 6th a couple of times today, right? So today, Medicaid is an option. We are very concerned that in 10 years from now, it may not be, right? But right now, if God forbid one of you called and said, my spouse, my sister, my cousin, my aunt and uncle, my brother, whoever needs care, what do? We're going to turn to Medicaid for the time being, right? But you got to make sure you have that power of attorney in place, because using that power of attorney, that's how we're going to be able to tell you what to do to protect your assets to get that person to qualify for Medicaid. But without that power of attorney, you're not going to be able to do it. So you see how this whole thing ties in, right? We're not just making it up. It actually works together.
And without it, we'll end up doing a Article 81 guardianship. It's going to take us a year to have a guardian appointed to then get you the help you need.
And $20,000 later, you'll have a guardian, right? And you'll be stuck in the court system for the rest of that person's life. So power of attorney is our key, right? So that would be the option, the third option, to engage in planning to try to get Medicaid care for long-term care, right? So that was my second additional concern. And the third thing I wanted to touch upon is taxes, right? Taxes are a big concern for a lot of us, but not a concern for everybody, right? So when you pass away in New York State, there is something called an estate tax. The estate tax, in order to pay estate tax in New York State, your assets have to reach a certain threshold, which is currently $7.1 million. So if you have less than $7.1 million, you're below the threshold, there's no estate tax. So when you die, your kids will not pay taxes on your assets. Zero, nothing. The federal government has a higher threshold. They're at $13.9 million. So if you have less than 13.9 million, again, no estate tax through the federal government, okay? But what's counted in your estate is literally everything, even your life insurance death benefit. So if I have $3 million in life insurance, I'm already almost halfway there, right? If you add my house to it, if you add some stocks, maybe a second house, I may be at $7.1 million. So it's really important to evaluate how close you are to that number, right? And I've had clients come in before, and I don't know if you've had this happen to you yet, but I've had clients come in who don't really want to give me numbers. They're just like, yeah, it's a couple dollars here, a couple dollars there. And then I start talking to them and I'm giving them numbers and figures, and they're like, oh boy, I got to start telling the truth. And then all of a sudden, they got 4 houses, they got a couple $1 million in savings, you know, and that all comes together and creates a tax. So it's really important that when you're talking to your attorney, that please be very honest. Tell us everything. We really need to know it. It's not because we're nosy, but we need to be able to best guide you. And that's the important point. The goal is to be able to give you the best advice, depending on what your circumstances are. So from the estate tax threshold, if you don't meet those numbers, you don't have to worry about it. Now, a lot of people are coming to me lately. I don't know, there must have been a TikTok or something on Instagram or something where they're saying, oh, I'm worried about when I die, if my kids are going to pay taxes on my home, let's say, right? And so, or they're going to pay taxes if I don't put it in a trust, which is not true. You don't get special tax exemptions because you put it in a trust, right? What the intention here is to minimize capital gain tax when you die. So let's pretend, right? If let's pretend somebody bought a house, and I'll talk about the area I know. I'm from Astoria, Queens, right? So I know that a lot of my older clients bought houses in Astoria in the 1970s for like $70,000. So we'll start, their basis is $70,000, right? And now their houses are worth $1.5 million. If they were to sell their houses tomorrow for $1.5 million, they've made a profit of almost $1.5 million, and they may have to pay capital gain tax. They will have to pay capital gain tax on that. Now, if it's their primary residence, they get certain exclusions, right? $250,000 per person. But if they don't sell their house and they give their house to their children at their death, meaning the trigger of the children receiving the assets is death, at that scenario, the children will not inherit it at the value that mom and dad bought it for, but they'll get something called a step up in basis. So if mom and dad pass away and the house is now worth $2 million when they die, the kids will get it at the $2 million mark. If they get it at $2 million, that means there is no capital gain tax if they sell it for $2 million. So you inherit it at the value that it has at the date of your death. But instead, if mom or dad were to give that house to their child during their lifetime, then mom or dad would be transferring their basis of $70,000, which was their purchase price, to their children. Now that 70,000 is not exact. It may be minus depreciation, because the accountants depreciate if it's a multifamily, or plus appreciation if the parents have put money into the house and declared it on the tax returns, right? So it's important to decide when you're gifting your assets or giving your assets away, what is the tax basis of that asset? And if an asset has appreciated significantly over time, you don't want to give that away. You want to instead give that asset away when you die so that your child can get that step up in basis. Now there's a question, do you think that the federal estate tax credit will drop on January 1st, 2026? All bets are off. I have no idea what's going to happen in January 2026. Okay, but if I had to make one guess, right? So what Anthony is referring to there is the federal, we said before, 7.1 for New York State, 13.9 for the federal government. Right. January 5th of 2026, 13.9 is supposed to come back down close to where New York is, right? So because that actually inflated in 2019 when Trump put in a new rule at that point, it went from where New York was, which was 5 million at the time, to about 11. It was 5.5, it went up to about 11 million. It's been increasing slowly, but in 2026 it's supposed to plummet back down. It was a very temporary, period of time at which that estate tax was going to rise, and then it's supposed to come back down. Now, personally, and this is not based on anything other than the fact that I think the Republicans will probably extend that because it's in their benefit to do so, to essentially extend the increased estate tax credit. So my personal opinion is that they're probably going to extend it. I don't think it's going to come back down, but I have no idea what's going to happen. Politics is politics. We'll probably find out on December 28th, like we do with everything that goes to expire and the government takes forever to make a decision. But that would be my thought. So estate tax is only really a concern if you're at those limits. And it's important to evaluate before you accept the house from your parents, let's say, right? What is the tax basis? It is really, really important when taking into account gifting or selling, right? People are like, oh, we're just going to sell this one and we're going to buy another house, not realizing that you're still going to have to pay capital gain unless it's an investment for an investment, right? There are certain other tax tools you can use to defray some of the capital gain tax, but you have to meet certain criteria. So one really important point is please talk to your accountants before you sell anything. Unfortunately, I feel like the accountant and the lawyer are the last two people who find out about these things, and the tax hit is pretty painful sometimes. Now that's the same for stocks. So if you bought Tesla for $100 a share and it's worth $1,000 and you sell it, you've made a $900 profit. The government wants their gain, right? They want their tax. It's the same kind of concept. So if you give me that Tesla stock as a gift for my birthday, you bought it for 100, I'm taking it at 100. So if I then sell it for 1,000, same scenario, I have to pay the capital gain. So it's really important to consider all of that when taking into account your estate planning, right? So we talked about our base, the first 5 documents, and we talked about avoiding probate through trusts or asset protection through trusts. We talked about long-term care planning, which is a big component. And then we talked about taxes. We could probably keep you here literally all day. I think we're at exactly an hour, and we were hoping to kind of limit ourselves to an hour so that you guys could go and do the rest of your important day. Probably some of you doing bedtime right now with the kids. There are a couple more questions I'd like to answer for you. Ivana, does a Medicaid asset protection trust have limitations when compared to a conventional revocable or irrevocable trust? All trusts are built based on the wording within the document. There is no way to compare 2 trusts side by side without looking at them physically, right? A Medicaid asset protection trust typically means that the grantor, the person who created the trust, made it irrevocable to them and is not allowed to receive principal from the trust, meaning that the asset that they've put into the trust is not able to be accessed by them. That's typically how it works. Some Medicaid asset protection trusts provide income to the grantor. So if you put your house in it and your house generates rent, you can receive the rent. Some of those trusts do not allow for income. It really depends on how it's formatted and how it's drafted. A trust always needs to be reviewed in order to be able to tell you what it says. I had a scenario last week where someone called me and said, we just need to know if our uncle's trust, it was revocable, gave us a step up in basis when he died. And I told her, I have to sit down with you. I have to read the physical trust. I can't give you instructions over the phone. I don't know anything about it. And when they came, the trust was so wrong. And there were so many things incorrect with it that had I answered her question, which is typical, like a revocable trust typically gives you a step up in basis, but that was not a revocable trust. It just said the word revocable in it, but it was not a revocable trust based on the terms. And it created 15 other issues that she had no idea about until I sat with her. So it's really important that the terms get reviewed. Is it normal for an irrevocable trust to include language that allows claims to be made against an irrevocable trust that need to be satisfied out of the assets of an irrevocable trust? I'm not sure what the claims mean. If it's the claims of the grantor, no. The point of an irrevocable trust is to avoid a creditor of the grantor. So that would be no. But Ivana, message me separately so we can discuss that. Kim, how much should we budget for setting up estate planning? So that all depends on circumstances, right? If you want to hear general fees, I would say in the general vicinity of $3,000 for a couple, $2,000 for if it's a single person. That would be an estimate, right? Depending on circumstances, things may have to be more complicated. Then it could change from there, but that's a very general cost, I would say. Trusts are more expensive. I'd say generally they're at about $3,500 or so to do a trust. The reason they're more expensive, they take more work. You know, it's an agreement, 20 to 30 page agreement, depending on circumstances, and it avoids probate. So you avoid the cost of doing the court with the will later on, right? So you end up paying the cost up front instead. Does anybody else have any other questions?
The POA question up.
Yeah, I'm going to go all the way to the back because I think there are 3 questions I missed. Shoshana, you had a question. Can a power of attorney make decisions anytime, such as now when I'm fine, or only if I'm incapacitated? You want to talk about the 2 POAs?
Goes into effect now, and they can make decisions and act and transact now, right? So that could be good in a situation where, you know, again, something happens to me and my spouse now needs to contact my employer, right? Or a banking institution that he's not listed on, et cetera. So that could be good in that scenario. Or it could be a situation where I'm appointing maybe a friend, right? I don't have relatives and I don't want them to act right now. And I can just say, hey, I prepared my documents. If something happens to me, this is where you can find them. Or this is my attorney. This is who you'll contact. You're listed on my documents. Please reach out to them, you know, in case of an emergency. So if we're worried that someone is going to use the documents now, then we don't necessarily need to give it to them now. I would caution that if you don't trust the individual now, then maybe
You shouldn't trust them when you're
the
incapacitated.
best person to appoint.
Right.
Right. So again, we mentioned earlier the springing powers. We typically avoid doing springing powers.
So there are 2 powers of attorneys, just to clarify. There's one called a durable power of attorney, and there's one which is what Kristine is talking about now, called a springing power of attorney. The durable is in effect immediately. As soon as you sign it and your agent signs it, your agent can use it. Now, there are very specific instructions on the power of attorney. You have to follow the instructions of, it's one of the pages, it's one of the powers that the agent accepts. You have to follow the instructions of the principal. Where there are no instructions, you have to act in their best interests, right? So they're not supposed to take the power of attorney and just run wild with it, right? That's the rule. The rule is, as long as you're well and you want to handle certain stuff, you handle them. If you're not able, that's when they should take over. But The durable does allow them to take over right away. The springing only kicks in when certain conditions are met. So if there was a situation where the person became incapacitated, the doctor would need to attach a note to the power of attorney that says that this person is incapable of managing their financial and personal affairs. That way, the agent can now act. I tend to recommend against the springing just because it can get very complicated proving that that person is not able to do something. I have a lot of clients in this really gray area where in the morning they're great, in the evening they're giving all their money away to the home health aide, or they're running outside the house without any clothes on in the middle of the winter, right? Because they don't know and they're not able to make decisions for themselves. So, you know, there is that gray area where I'm very concerned. Now, if there's a scenario where you want it to only kick in when you're not well, that's fine. We can do a springing power of attorney. Like I said, it's not as used just because of the conditions. I always say, if you trust your person to transact for you when you're not able to look over their shoulder, I would hope that you trust them now too, to make the right decision. For a lot of clients, we do durable power of attorneys and I tell them, don't give them out. Just hold on to them. There's no reason why my sister should have my power of attorney. She knows that if something happens to me and my husband, she's going to come to my office, pick up my power of attorney, or she's going to go home where I have it in the cabinet and grab my power of attorney from there. She's not using it before that, right? Okay. There was another question here with regard to, can anyone contest a guardianship? Absolutely, right? And there are a lot of scenarios too where I have families where maybe one parent is very abusive or one parent is close to having their rights terminated as a parent, right? It's so important that that other parent who's meeting with me give me all of that information. I want to build a file against that surviving parent as to why that parent should not have guardianship over the child when my client dies. So I always tell them, bring me the documents, bring me the proof of if it's abuse or the APS reports, bring me whatever it is that you have to state why this surviving parent, if they survive you, should not have access to the child. But a biological parent or an adoptive parent has primary rights to that child. We can contest it if we need to. You know, if grandparents come in and say, I don't think the person my daughter nominated is fit to do it, absolutely, they can come forth. Grandparents have a right to be part of that proceeding. If there are certain people you definitely don't want involved, you should make that very clear in your documents too. I have clients who have family members who we don't want anywhere near the kids. I make it clear in the documents. And if they read it and they get upset, oh, well, too bad. As long as your wishes are there, so the judge knows this person is not fit to be a guardian in any means. I don't want them to ever have control over my kids' finances or their personal needs. A couple more questions, and then I think we're going to wrap it up. I think we got everything. There we go. Yeah, I think we have everything. Are there any other questions that anybody may have? Okay, I think we're good to go. Thank you so much for joining us tonight. It was great having you here. We hope that it was very informative and that you got as much information as you possibly can. I think you have our contact information. Feel free to reach out to us with any questions that you may have. We did record it, so we think that it'll be shared probably by email with by Roy. I have a feeling he'll send it out to everybody. But if you ever have any additional questions, feel free to reach out to myself, reach out to Kristine, and we're happy to help you or anybody that you think may benefit from our knowledge. Thank you so much for joining us.
Thank you. Have a good night, everyone.
Good night.